Hello friends, the RERA Act 2016 has provided with a significant robust mechanism for the settlement of disputes between the promoter and the home buyers. Now the home buyers are basically the investors who are investing in the real estate projects, which may be a plot or a construction site or a flat. So the promoters are those persons on the other hand who are builders or real estate agents or the landowners. So these persons on the latter side have a fiduciary relationship among the former side who are the home buyers. So before the 2016 there was a constant exploitation because there was no expressed act which governed the field of real estate. The RERA Act 2016 provided a mechanism to compensate if the possession is not delivered within a stipulated time as per the agreement for sale. The agreement for sale becomes a crucial document or a piece of evidence when the possession is delayed or the construction is not completed within the stipulated period of time. The agreement for sale is or it acts like a contract between the two parties, establishing a contractual relationship between them. And the RERA Act 2016 under section 18 has prescribed a mode of compensation if the possession is not delivered on time to the home buyer. The compensation mechanism here in section 18 has been expressed as the if the possession is delayed and the home buyer decides to withdraw from the project. In that sense, the real estate builder or the promoter, it becomes binding on him to pay the whole amount paid by the home buyer to the promoter at the time of signing the agreement for sale, with the interest rate of around 8.70%, that is MCLR, present SBI's MCLR rate plus the 2%, which makes it equivalent to 10.70%. So the whole amount has to be paid back to the home buyer with the interest rate of about 10.70% in Karnataka. So this is the compensation mechanism. And additionally, if the home buyer says that he has went through mental agony and claims any additional damages, that should also be complied with. So this is an automatic binding law upon the promoters to comply with if they are delaying the possession and the home buyer withdraws. Additionally, the section 18 also provides that if the home buyer is not withdrawing and is deciding to continue with that project, but the possession is not yet delivered, which would be the case. So in that instances, the amount which is paid by the home buyer to the developer is not required to be paid by the promoter, but the interest is to be paid to the home buyer unless and until the actual possession is given. So the interest rate or the payment of compensation start as soon as the stipulated period mentioned within the agreement for sale elapses. So if the possession is on the time of elapsing not transferred in the favor of home buyer, then it is binding on the promoter to pay interest to the home buyer unless and until the possession is granted. So let us take an example or a practical aspect of this. Let us consider Mr. X has purchased a property from a well-known real estate builder and has paid about 95% of amount for a flat which he has desired to purchase with the promoter, and they both enter into an agreement for sale at 2019 wherein they agree that the possession would be delivered by 2022. So what is the remedy Mr. X would be liable to? The remedy here comes under section 18. The section 18 states the compensation procedure or the compensation mechanism. The compensation mechanism here, if the Mr. X decides in 2023 that he is not willing to proceed with this agreement and he is deciding to withdraw from this, herein what happens is the agreement of sale is terminated, and additionally it becomes an evidence for the possession delay. Now as X is withdrawing from this project, the compensation for him would be, for example, the 95% amount which he has paid earlier would be calculated at the rate of 10.70%. That amount of interest plus the 100% of whole refund amount would be binding upon the real estate promoter. Unless and until the whole amount is paid, they have to be paying the interest rate at rate of 10.70%. That is the 95% of amount in this present case into 10.70%. So that would be the amount of compensation unless and until the whole amount of 95% of amount which he has given for the purchase of the flat is transferred to the home buyer. But now let us consider a fact that if X decides to not to withdraw from the project and give him the delivery of possession, in this case what happens is unless and until the possession is transferred in favor of the home buyer, the promoter keeps on paying only the interest rate for the amount given by the home buyer to the promoter. In the present case, Mr. X has paid 95% of amount. Let us keep it, for example, 2 crore. So that 2 crore amount into 10.70%, that would be the amount payable to the home buyer unless and until the actual possession is given of that flat to the home buyer. So the RERA Act 2016 mandates a compulsory registration by the promoters for any project which is more than 500 square meter or more than 8 apartments, and they are advertising it for the purpose of sale, or they have distributed the information with regard to the particular projects and sanctioned the plans. All those documents, all those things should be uploaded in the RERA website of the particular state. And the RERA Act prescribes complete transparency with regard to the project construction and the project documents which have to be stated in the RERA website, and it has to be under the visibility of the common public, so that each and every home buyer is aware that what is the current status of the project and what are the titles with which the promoter is acting to construct the project and exercising his right to sale. I have tried to simplify this section with a practical aspect. Hope you like it. Subscribe for more. Thank you. Now let us think that Mr. X didn't receive the possession even at the year 2023. The promised date of delivery was 2022.